My name's Keith Miller. Similar to Brian, I'm a white-collar litigator out of the New York office at Perkins Coie. My background, I was with the SEC a long time ago in charge of broker-dealer enforcement in New York. Since, I'd say, 2012, I've been involved in representing companies and individuals in connection with mostly the SEC enforcement investigations and private litigation. So I've done probably over 24 different enforcement actions, always defending. And on the civil side, I've been defending companies in connection with private litigation. They range from, obviously, is it a security to just founders' disputes. So what I wanted to talk about is how do we avoid NFT litigation, right? So from that, I think the best thing to do is tell you a little bit about what went on with ICOs and cryptocurrency, talk about the litigation there, and then I'll pivot and give you lessons learned. So, we all know that there are a tremendous number of issues with digital assets and cryptocurrency legal issues. Regulatory status. You've got whether it's a security, whether involved as a broker-dealer, whether you're a commodity pool operator, whether you're a commodity trading advisor, whether you're an investment advisor, whether you are subject to some type of registration, like securities registration, whether you are a money service business, tons and tons of legal issues. And those form the basis for most of the litigation and regulatory investigations. So who's bringing these? Who brought these types of litigations and investigations? Primarily, I would say the SEC. You've seen the CFTC. You've seen DOJ when there's a lot of fraud involved. You've seen the IRS trying to collect its nickel. FinCEN hasn't been involved with licensing, money service business licensing. You've got some state attorney general's offices that have brought cases. And obviously, you have private litigation. The private litigation, a lot of people ask me about, it hasn't taken off, frankly, as much as we, the defense bar, thought it would. But it has been there. So let's first talk about registration. So we all know we all know the SEC has put out some guidance, albeit, I would say, not much. And their initial focus was back in 2017 when they brought out the Dow report and the Munchie order. That was 2017. Let me talk about the major actions that they've brought. Telegram, we all know, we've probably heard about the Telegram case in the Southern District of New York. That was settled. Telegram had to settle that case, and they agreed to return more than $1.2 billion and pay an $18.5 million civil penalty. And the reason I bring this up is I want people to understand the ramifications. We heard from the prior panel about, well, one position was it's always a security, another position of, well, it's facts and circumstances, and it is. Maybe you can push the envelope. I want to make sure everyone understands the ramifications, right? We all saw probably in September that Coinbase was threatened with a lawsuit by the SEC. Lots and lots of reputational damage. They ended up going a different way. Kik, another big case in the Southern District of New York. They ended up paying a $5 million fine and agreeing to other relief from the court. Ripple Labs, big case in the Southern District of New York. Everybody's watching that case in the legal community. We'll see what happens there. Everyone's watching that case. Another case, Library, big case in the District of New Hampshire. Everyone's watching that. So this will help potentially define Howie and how it's going to go forward. Again, everything's facts and circumstances, but these two cases are the cases right now that people are watching. I should note on Friday, I believe it was, a Connecticut jury found that a security or a offering of digital currencies were not securities. So we're starting to see some cracks in the pavement here. And so stay tuned to see if there's more guidance. Unfortunately, this is a gray area. And I know lots of people say, I hate gray areas, just give me black and white. As the prior panel talked about, it's not a yes or no, black or white answer, particularly in this area. You've got new innovation with old laws trying to meet. And unfortunately, we're not getting enough guidance from our regulators, and we're not getting enough legislation from our Congress. So to the extent you're interested in SEC action, just go to our website. You can see we have a digital asset timeline of every case where the SEC is brought, every case where the CFTC is brought, and it talks a little bit about it. So now let's pivot into NFT, area of litigation. I'm only aware of one securities class action that's out there, and that's against Dapper Labs. It was initially filed in state court. It was removed to federal court. It's in the early stages. Stay tuned. But how do we avoid litigation? I've got a couple more minutes. First and foremost, smart contracts are still vulnerable to disputes. You still need a lawyer, and proper documentation is paramount. So let me talk about what I will tell you to look at most foremost. Terms of service. TOS. That is the contractual relationship that a builder of an NFT has with someone who's buying the NFT. Terms of service. Again, that binds everything. So, for example, if you have an arbitration clause in your terms of services, and all of a sudden the person who purchased your NFT decides to sue you, well, guess what? A good defense attorney is going to say, no, that belongs in arbitration. I'm going to compel arbitration and get you into arbitration. Form selection clause. In your terms of service, put down the forum that you want to litigate, where it is. Do you want to be in Delaware, where there's lots of business interpretive law? Do you want to be in California, where I would argue it's more pro-plaintiff? Think about these things. Disclaimers regarding liability, damages. Put them in your terms of services, right? You are limited damages here to the amount that you purchased this NFT for. Put in the investment purpose. You are not buying this for investment purposes, if that's the case. IP licensing issues, that's the hot area right now for NFTs. And that is, what do you get? And I know there's a panel coming up. What do you get when you buy this? What rights do you get? Can I transfer those rights? If you're only getting a limited IP license, then you may not be able to actually sell that. So I'm out of time, but let me just tell you that there's one last thing, big issue that's on the horizon. And there was a Bloomberg article last week about this. The headline, an NFT just sold for $532 million, but didn't really sell at all. I've heard people say, this is price discovery. Guess what? It's called mail fraud. And the SEC and DOJ will be investigating these stories. They get their tips and they get their investigations from high-profile media. So with that, thank you.